So thank you for joining today. This is a short and sweet overview of managing probationary periods with me, Liz Burley from Burley Law. Today we're going to be thinking about what a probationary period is, why it's important to manage actively that period of time with a new employee, and what are the risks if you don't do that and if you terminate employment at the end of a probation period or during it. It's going to be relatively relaxed and informal, so if you have a question, you can either ask it at the end or pop it in the chat and we'll see if we have time for them. We are recording the session, and just for GDPR purposes, when we put the recording out, names of attendees won't be visible. And the session will last up to half an hour. I'll talk for about 20-25 minutes, and then if there are any questions, it might go on a bit longer after that. So, taking a deep dive in then, on to our next slide, just an overview of what we're going to cover in this short time together. So, we're going to think about what is a probationary period and what is it for. We're going to think about setting up for success and what that would involve, what you need to think about, probably even before you get into the start of the probationary period. For getting a successful outcome out of a recruitment. We're going to think about performance management if it's needed. We'll then go on to think about what the formal probationary review should look like, legal risk areas that you need to be aware of, and then some final tips and takeaways. So on to our next slide. So the first thing you need to be aware of is that, and this might be a surprise to some, that a probationary period in employment at the moment is not a legal requirement. There's nothing in law that says that an employee must be given a probationary period, or that any particular requirements, process-wise or in terms of termination of employment, must apply. That is set to change from sometime next year, and I can't be precise about when, but we're probably looking at late into next year. You've probably heard of the Employment Rights Bill. It's full of changes to employment law, and probably the most headline-grabbing piece of news is the new right to claim unfair dismissal from day one of employment. Now, we do know that it's likely that there will be some, in the detail of that law when it comes, there'll be some kind of initial period of employment, and there'll be some minimum requirements around process, performance management and termination during that period of time. And we think it's going to be about 9 months when it's set in law. But as I say, we don't know the detail on that yet. The current law is that you can manage probationary periods in the way that best suits your business. And really, apart from the statutory rights, which I'll cover a little bit later, probation is a matter of contract. So it's about what's agreed between employer and employee as to what terms will apply about notice, ending of employment during that period of time, and how long that period of time will be. What is a probationary period for? Well, it's about assessing the employee. What are we assessing? We're assessing their suitability for the job that we've hired them for. We're assessing whether they've been truthful, fully frank with us in their CV or in the recruitment, the application form, about their abilities, their qualifications, their length of experience, and how they match up to the job description. It's about assessing their delivery. Are they able to turn up on time? Are they reliable? Are they trustworthy? And it might be about their attitude too. Do they fit with the culture, the way we do things around here? All of those things are important to assess during the probationary period. So on to our next slide. So things that you need to be aware of when you're thinking about having a probationary period in place, and everybody in my view should have a probationary period at the start of employment. It should be very clear to an individual before they start day one of employment that there will be a probationary period. It should be clear how long that will be for, and it should be made clear what notice period will apply if their employment is ended during or at the end of that period. It should also be made clear that the employer has a right to extend that period of time if there are concerns and the employer wants to allow more time to assess suitability. Now, typically, probationary periods range between 1 month and 6 months. A period longer than that would be unusual, but not unlawful. You can set a longer period if you wish. 6 months is pretty much, I would say, enough to assess someone's suitability for all the things I've described. But you may want longer in the particular context of the business or organisation that you're recruiting to. And at the lower end, I would say that 1 month is nowhere near enough to assess somebody's suitability and whether they're a good fit for the organisation. So the probationary clause in your contract of employment template should specify all of these things very clearly. Now, as regards notice periods, there is a minimum entitlement to notice for every employee. After 1 month of employment, that is 1 week minimum notice. But thereafter, 1 week up until they reach 2 years of employment. So during a probationary period of less than a year, you can set that notice period at 1 week. That's in line with statutory minimum. And typically, the notice during probation would be shorter than the notice period that would apply after probation. Why? Because you want to be able to terminate quickly. You don't want a long notice period during probation. You want to be clear about the notice that will apply, because if you have one size fits all notice period of, say, a month in your contract of employment, and you dismiss during probation at the end of it with less than 1 month's notice, with less than the contractual period, you will be operating in breach of contract. That could give rise to a claim for breach of contract or wrongful dismissal from the employee, be worth a month's pay, or up to a month's pay, depending on what period of notice you did give. But more widely than that, a breach of contract by the employer can put at risk any contractual obligations it wants to rely on after employment has ended. Now, usually this might apply to more senior employees than junior, but it depends on the business and depends on what's in your contract template. But in some cases, you will have restrictive covenants that you want to rely on post-employment. Those are restrictions on what the employee can or can't do, working for a competitor or in a competing area of the industry. If you want to rely on those contractual restrictions and any other post-employment obligations around confidentiality, you must not breach the contract when you terminate, and the notice period must be as is set in the contract. So that's why that's important. You have a shorter notice period during probation and possibly a longer period to follow once employment's confirmed after probation. If you're extending probation, make sure that you have that confirmed in writing and the reasons why probation's been extended, together with any support or training or other help that's going to be given by you, the employer, during that extended period. So next slide, please. So day one of employment, we've got our contract in place, we've done a successful recruitment, we hope. We've done a nice employee induction, day one. How are we going to move this relationship forward to make sure that we are actively managing the probationary period, getting the best out of it, but also ensuring that we are in a good place to take action if success doesn't follow? The first thing is to have regular check-ins with this new recruit, and I would suggest that they're set at weekly or fortnightly. They're no longer than half an hour, and they're just touch points to make sure that everything is on track, to check if the employee has any concerns or questions about what they're being asked to do, and there might be a little mini review of work that's been done, during that review period. It's important to give feedback very early in the relationship, both the positive and the negative. And I acknowledge that giving negative feedback can feel like having a very difficult conversation, but it is necessary. Getting on record concerns early is the key to a good outcome and managing risk if things don't work out well in the long run. Making sure that you are supporting with training, so identifying during those check-ins what training might be needed. Having a development plan or a probationary plan, you can choose to call it what you like really, but a plan in place of what is expected from this individual during the probationary period. What does success look like? What milestones might they have to achieve? What key behaviours or performance metrics are there that they need to meet to demonstrate that success? All of that needs to be clear to them, otherwise you're setting yourself up for possible dispute in the future and possibly even claims further down the line. And of course, the people who are delivering this oversight during probation need to be aware that consistency is key. What they do for one employee must be consistent with what they do for another. So a process and document templates, review notes and template meeting invites are very important if you're in a bigger business where you are relying on managers to do what's needed to be consistent across the board. As I said, referring to notes, you must make sure that you document everything, how things are going. So meeting notes are important, development plans, as I said, any adjustments to the development plan if things are agreed along the way, and follow-up emails or letters that are sent to the individual if there are concerns and things need to be escalated. Early intervention is very, very important. So during that probationary 6 months, let's say, you might decide at the beginning that you're going to have a final probationary review at the end of the 6 months, but you might have a midway review, a mid-review, to just make sure that everything is on track and things that have been highlighted are being actioned and everybody's clear on what's expected for the remainder of the probationary period. But if there are concerns, you shouldn't wait until those 2 points. They should be obvious, they should be understood, and what's expected to address those concerns should be clear to the employee much earlier than that. Next slide, please. So talking about this formal either midpoint or end of probation review meeting, it should not be a surprise to the employee. They should know that it's coming. I talk to businesses that want to address things when they come to the end of this period. And when I ask what's gone before, what process has been followed, very often I see nothing, or I only see informal conversations. So my advice would be to make sure that, as at day one, the way in which the probationary period is going to be managed is clear to the individual, but there's also a date in place for the formal review point so that they know what's coming and when. And during that review meeting with their manager, there might be somebody else present, but I would suggest, unless you've got an HR department who typically attend meetings, it's probably going to be a manager and their line report is under review that attend that meeting. So considering their achievements, and there will be achievements to highlight in most cases, areas of concern, whether that's attendance, attitude, behaviours around the workplace, dealing with customers, or some other aspect of their performance, need to be outlined very clearly in this meeting. And then the decision confirmed at the end. Most of the time, the decision would have been made before you get into that meeting. However, you might need time to deliberate, and if you do, that's absolutely fine. You can adjourn that meeting and come back the next day to confirm the decision, or you can make the decision there and then after considering, maybe after a short break. And that decision will be one of three things. You'll either confirm their employment is continuing on a permanent basis and they've passed probation, you can extend the probation period, or you can confirm end of employment at that point. Now, I'm not going to get into specifics around extending probation, specifics around termination of employment. You can look at my previous webinars previous webinar on contracts of employment with some useful guidance on termination. But as I said earlier, make sure that you follow whatever termination notice period is in the contract of employment. And just a word on disciplinary and grievance procedures here. So if you're terminating for reasons that are about capability or conduct, you're not going to be hung up to dry on unfair dismissal law when you're dismissing at 6 months, but you might have to face a claim for discrimination, or you might get challenged on that you've breached the contract by terminating at that point. We mentioned notice periods earlier being relevant to breach of contract, but if you have a disciplinary policy and procedure that is badged in your company policies as contractual, then you would be expected to follow that to the letter to terminate somebody's employment during or at the end of probation. And if you don't follow it, you'll be in breach of contract. So that's why it is advisable to make your disciplinary and grievance procedures non-contractual and to make that clear in the policy itself. That way you can depart from, you can adjust the process to deal with any misconduct during probation or after probation. And also you won't be facing a breach of contract claim if you do something in a different way to what your policy and procedure states. And on discrimination, whether or not you have a contractual disciplinary and grievance procedure, consistency is important when it comes to thinking about discrimination claims, because discrimination is all about complaining of less favourable or different treatment that is due to a protected characteristic like race, religion or disability. If you behave differently in disciplining or terminating someone's employment because of a conduct or capability issue during probation, and they're aware that that's different and they can relate the difference in treatment to their protected characteristic, then you could be at risk on discrimination. So consistency is not only key from a more positive point of view, because it harmonises the way employees feel the employer is behaving towards them, and it creates better engagement, but it's also very important to keep in your mind for legal risks. And as I said earlier, documenting everything is very important. Whether or not your decision is to confirm employment, extend probation or terminate employment, that should be in a letter to the employee and held on their employment file. So moving on to the next slide. Key legal risks, I've covered a little bit along the way. I've talked just about discrimination claims. So, I'm going to come on to think about unfair dismissal and also wrongful dismissal. So first of all, thinking about unfair dismissal. The right to claim unfair dismissal at the moment is set at 2 years of continuous employment. Nothing to fear there then. If we sack somebody for well below that 2-year threshold, we're safe. Well, yes, to a more or less pretty certain degree. However, there are some types of dismissal that are defined in law as automatically unfair. So if the reason for dismissal, even at 6 months, 9 months, or anywhere less than 2 years, relates to one of these areas, you won't be able to defend it. It will be an automatically unfair reason for dismissal, whether or not you're badging it as a failure to pass probation. So the reasons that are automatically unfair are maternity and pregnancy, health and safety, trade union activity, and making a flexible working request. Apart from those automatically unfair reasons, what else might you have to fear in terms of a legal claim? On discrimination, as I say, if there's any hint that there's a protected characteristic, and there are 9, so any of those could apply at the end of probation. If there's any hint of an individual having that profile that might mean there's some risk attached to terminating, then you're probably best advised to get advice on how to respond to that complaint, or even earlier than that, how to ensure that communications are crafted so that the complaint is less likely to succeed if it is brought. Remember that claimants, that's employees, whether they're still in employment or their employment's come to an end, have 3 months typically to bring a complaint of either unfair dismissal or discrimination in the employment tribunal. So they have to act quickly. But 3 months can be a long time, and during that period, the employee would have to notify ACAS that they're going to bring a complaint, that they're not happy. And so you probably would find out fairly early on during the 3 months time frame whether or not the individual is going to pursue things and escalate this through into, or if they intend to bring an employment tribunal claim. You'd have some opportunity to engage through ACAS with that individual and either settle the claim or explain why you think you're able to defend the claim. And any employee can do this. It doesn't cost any amount of money to lodge a tribunal claim. So making sure that you actively manage your probationary period for all employees will mean that not only are you setting up for the success factors we talked about earlier, but you're also able to demonstrate in any case where you terminate employment that your decision was sound, it was made on a good basis for good reasons, that it's been well communicated, and that there is no hint of less favourable or different treatment that would give somebody the footing to claim discrimination. There are other reasons which might typically, might in law amount to whistleblowing, but they're unusual. And unless you're working in a regulated environment, they're unlikely to apply. But it is possible for any employee that's been sacked under 2 years to make a whistleblowing complaint, and that their dismissal has been linked to some kind of whistleblowing. And finally on that list, wrongful dismissal. Well, that's just another way of saying somebody hasn't been given their full contractual or statutory notice entitlement. And as I said earlier, making sure that your notice periods are differentiated for probationary periods should help you there. And next slide, please. My final tips and takeaways from this session are, in summary, to structure your probationary periods properly for every recruitment decision that you make, remembering that according to the CIPD in 2022, the average cost of recruitment for senior managers is £3,000 and £1,500 to £2,000 for other employees. Recruitment is an expensive exercise. That was back in 2022. I dare say there's been an increase on those figures since then. Recruitment is not just costly in terms of recruitment fees, it's also costly in terms of time and effort. And if you've got to the end of the recruitment process, it means that you believe this employee is right for the business. So that investment needs to be treated with care. So structuring that probation is the right way to do that, not only to manage risk that might lie ahead, but to, more importantly, to make sure that that recruitment decision you've made turns into a successful hire. And probation really needs to be built into the induction process to make it meaningful and give it the best chances of success. Document everything fairly and reasonably and clearly, as I said, meeting invitations, meeting notes, outcomes of meetings, concerns backed up by evidence. And just a word on documents. So the data protection law that applies to any business in the UK extends to the handling, processing, storing of employee data, personal data. So any employee can make a request to access the data that you hold on them, whether that is somebody during probation, somebody that's left your business, even somebody in employment currently, or job applicants. All of those categories of people can make subject to access requests, and they do it because that's a very useful weapon, and it's a good way of finding out whether there is some kind of smoking gun, or some information about how their employment has been handled, and communications internally between managers, for example, or between managers and HR, that might tell them something useful that they want to know if they're trying to build a claim against the business. So having GDPR, data protection law, in your mind, making sure that you are only keeping what you need to keep, and for as long as you need to keep it, is really important as a wider thing to consider for probationary periods. Manage the employment and their performance actively, as I say, getting ahead of issues. It is not unlawful to terminate probation early into the 3 or 6 month period, whatever period you've set. You don't have to wait till the end of it. And if it is becoming obvious early that this employee is not suitable for whatever reason, then probably 9 times out of 10 it's going to be better to make the decision early, unless there is some reason why their performance has dipped, their attendance has dipped, that you can get under the skin of, and they will engage with you about that. So make decisions early unless you feel there is something to be gained, some advantage by extending their employment to see if things get better. And my next slide, please. Useful resources that you might want to turn to. As ever, ACAS is a good source of information. There is, last time I checked, there's quite a useful staff induction section. If you go onto the acas.org website address and just search in the search box staff induction, it should take you to the resources they have there. Burley Law we have a YouTube channel where we have some valuable resources that you can watch for free. They include previous episodes of the Lunch and Learn webinars. Our last 2 sessions were on contracts of employment and employment status. And you can also listen to podcasts that I've hosted with guests on issues and topics around healthy workplaces. And we are going to send you a free guide after this session. It won't be on contracts of employment as it states there. It'll be on managing probationary periods. So I'm going to send you a template for a checklist that you can keep to hand when you're managing probationary periods in the way that we've described. And finally, just want to ask if there are any questions, and if there are, you can pop your mic off or put them in the chat. I'm going to thank you very much for attending. If you do need to pop a question over to me over email, very happy to hear from you. And otherwise, we have just a note of when our next Lunch and Learn session will be. Can we pop that on the screen? Thank you. So our next session is on the 8th of May, and that'll be all about managing holidays, so holiday entitlement, holiday pay. So I hope to see you there. Otherwise, thank you for attending today, and enjoy the rest of your day.